Shall I start, ma'am?
Yeah, we can start.
Okay. A happy and knowledgeable morning to one and all gathered here. Welcome to challenges. Look for the opportunities in every situation to learn and grow in wisdom. We hope that this FDP will help all of you to learn new ideas and concepts towards intellectual property rights. It's a great moment and pleasant feeling for me to welcome you all for a one-day faculty development program entitled Intellectual Property Rights, organized by Institutions Innovation Council of CPG College of Arts and Science, Bangalore. On behalf of INC and on my own behalf, I feel happy to welcome you all again. With this note, she is open for possibilities, she is open for choices, she always welcomes new ideas, she always eager to learn, she never going to close her mind from learning. She is none other than our beloved principal, Dr. N. Muthamani ma'am. I invite ma'am to welcome the gathering.
Thank you, Deepika. A very good morning to one and all present here. And I welcome you all for this today's session. I am pleased to welcome you all for this faculty development program on intellectual property rights. And we know that now the buzzword in MHRDs and innovation cell is the intellectual property rights. And this faculty development program, it aims at providing the key inputs about the intellectual property rights and why it is so much important. And being a teaching fraternity, what we should know about this IPR. Because we are also having many intellectual properties, and whether we are having the rights and whether you are using the rights properly and whether we are using the others' properties rightly. So these things we should know being a teaching fraternity. So in this modern era, we know that intellectual property rights, it plays a significant role on the trade of every nation. And in this digitized world, there stands a high risk of creative ideas getting stolen without the consent of the author. Even when we are downloading a PDF, an image, a video file, or any text, or any notes regarding our subjects, everything, it belongs to the author, and we should get the consent from the author. So this, I hope this faculty development program will give an insight about the intellectual property rights and why the strong intellectual property laws are needed for the overall contribution in the economy of the respective countries. And IPR is one of the sources of security for intangible properties which are still open to the public and which can be quickly replicated by anyone. We in our college, we have established our IAZ 1 month before, and by the sincere effort of our IAZ coordinator, Dr. Hari Krishnan, we are doing so many programs and many activities are going on under the IAC initiative. And my sincere appreciation to Hari, you are rocking. And for this IPR FDP, we are having an eminent personality as our resource person, and we are looking forward for further support and guidance from you, sir, for your institution in the future also. I wholeheartedly welcome our chief guest, Mr. Satish LLM, sir, for this faculty development program. Thank you, sir, for accepting our invitation to provide an insight on IPR. And I also welcome all the learned professors from other colleges and our faculty members also, who are the ultimate beneficiaries of this faculty development program. Once again, I welcome you all. Thank you.
Thank you, ma'am, for your energetic welcome. Next, I would like to invite Dr. R. Kumarasan, Department of Commerce, Head Department of Commerce with CA, PA and IT, to introduce our guest of the day.
A very good morning to all. I take immense pleasure to welcome and introduce our resource person of today, Mr. Sarees Agnigan. He is a very knowledgeable and experienced person. He done his Bachelor of Commerce from Brihan Maharashtra College of Commerce, Pune, and he has attained his Bachelor of Law LLB from Raja Lakamgowda Law College, Belagavi, Karnataka. On adding a feather to his cap, he has achieved 6th rank of the Karnataka State Law University, and he has attained his Master of Law LLM in Intellectual Property Law from Symbiosis Law School, Pune. On his work experience, Sir is presently working as an assistant professor at RL Law College, Belagavi, since 2017 to till. He also been working as associate attorney at Mindtrust India Private Limited in Pune. It is a US-based outsourcing company for 2 years, and he has acted as a resource person in various universities and colleges. He has also been actively participated in so many webinars and presented on many informative topics. Thank you all for giving me this opportunity. Thank you, sir.
Thank you, sir. In matters of style, swim with the current. In matters of principle, stand like a rock. With this excellent quote of Thomas Jefferson, I would like to invite our guest, Mr. Satish Anikindi, sir, to take over the session.
Thank you, respected principal ma'am and all other faculty members for the kind introduction. I am really honored to be with you all today on this occasion. I'm really happy that so many people are interested, which is rather the need of the time in this field of intellectual property rights. Before we begin with the session, I would just have one thing to say. The internet which I have here may not be as fast as we would all like to be. So to begin with, we will start with the PPT presentation and my camera on. I request everybody to switch their cameras off. If that works, well and fine. If there is any hurdle, if there is any audio or video break, then I will switch off my camera as well, so that my audio and the PPT would be on, and that would be a little smooth presentation. So with that thing, let me share my PPT with you. Just a second. All right, so I hope everybody is able to see the screen properly and listen to my voice clearly. So let us begin with our today's session. At any point, if you have any doubts, any technical issues, if you cannot see the screen, if you cannot hear the voice properly, just interrupt me and let me know. Now, when I spoke with Dr. Harikrishnan sir, I asked that the background of the audience and the overall need of this particular FDP. And sir said that because they are from a different background, so he's a mathematics professor. So he left the topic to me. And so I took the liberty, and because we have 2 sessions, sir asked me what would be the most useful thing for all the participants here, all the faculty members here. So because we have 2 sessions, the first session would be basically on overall intellectual property rights as such, right? Include the basic understanding of IP, intellectual property, and the different forms of intellectual property which we all are associated with, with which we all are linked with. We might be using so many IPs in our day-to-day life, but we may not be aware that this is intellectual property of somebody else. So in the first session, I will focus on different kinds of intellectual property available or in the world. And except one, that is copyright. I am keeping copyright for the second session, in the afternoon session, where I will exclusively deal with the copyright and one most important aspect to all academicians like us, and that is plagiarism. Right? Everybody now here, many of you might already be a doctor, a PhD scholar, or a research scholar. So this plagiarism thing is one which we have to be really, really careful about, right? Why? Not only because it is an offense, but there are very serious repercussions these days because of the new regulations brought in year 2018 by the UGC. So my afternoon session would be on those UGC anti-plagiarism regulations and copyright, because both are connected to each other. So in this session, let us begin with the basics of intellectual property, what IP is, and what different forms of IP are. Now, assuming that nobody knows much about IP, in the sense you might have heard about it, you might have heard the words like patent and trademark and copyright, etc. But what actually this IP is, in the simplest of terms, okay, it is associated with our intellect. The word itself tells us intellectual property, and it is about the creative mind which we all have. The humans, we have come so far, right, because of what we have here, the brain, the intellect. So whatever arises, whatever originates from this intellect is nothing but intellectual property, right? So it includes the words which we read, which we write, okay, and it is not only a textbook or some a novel or some research thesis, some PhD thesis or a dissertation. It is anything which we read. You take a newspaper, we read newspapers, right? We read some articles on our social media. Whatever is written is actually an intellectual property of the person who wrote it, right? The images which we see nowadays, it has become so easy for us to go on Google, copy some image and pass it off as our own, not bothering about the original photographer or the publisher to whom this picture belongs, right? The images, they are the IP of somebody else. The videos which we watch, the movies which we see, whether they are informative videos or entertainment videos, they belong to somebody else. The music we listen to, right? All these things, or most of these things, are available to us free, without cost. Nowadays, there are so many, there is a lot of free content available on the internet. And basically, after this COVID pandemic began, right, the government and all other institutions, whether private or government, they are into this online learning thing, right? There are so many. Now, Swayam, I don't know, you might already know it. Swayam is a platform by the government where a lot of content is uploaded, and very recently, some 2 days ago, I read that some more than 100 undergraduate and postgraduate courses are made available for free on this Swayam platform by the government. So many of these things which we use, they are available to us for free, but most importantly, free doesn't make it ours. Just because it is free does not mean that it belongs to us or we can use it the way we want, right? We have to always keep in mind that it belongs to somebody else, right? Including these sentences which you see on the screen right now, they are not my words. They are from this website, alexandrawrote.com, right? So I quote unquote these things, and I would like to add certain things, to this. That is, it also includes the products which we use, the brands which we use, right? What is a patent, right? Patent is nothing but an invention. So all inventions, whether they are useful to us or not, doesn't matter. At some point in time, we have used these inventions, these products, or the brands. With brands, there comes trademark, another kind of intellectual property. So the products or the brands we use, the food we eat, right? It might be surprising to you. Even some of the food we eat contains intellectual property. The basic thing, when I'll speak about it later also, plant varieties. Now there is a special law, Protection of Plant Varieties and Farmers' Rights Act. This law protects new varieties developed by the farmers or on behalf of the farmers. So these plant varieties are what? It is used as food. We eat them. Eventually we eat them. It may be part of fruits or vegetables, but the food we eat is someone's IP. Not even apart from this plant varieties, right? You take fast food items, whether it is about the Coca-Cola recipe, okay, it is considered widely that the recipe of Coca-Cola is a trade secret, that is confidential information, which is another form of intellectual property. It is a trade secret and kept so by the company for since many generations. And so there are KFC, a very good brand. So certain items, certain recipes of KFC, certain recipes of McDonald's, they are regarded as confidential information, trade secret by those respective companies. So it includes the food and it also includes the fragrance or aroma. Now it comes under trademark. There is a very new form of trademark which has arisen in the past few years, and that is these unconventional trademarks, which we call the fragrance, the aroma. I'll talk more about it when I talk about that topic. Okay, so all these things, they are nothing but belong to this big family of intellectual property, the big world of intellectual property, and we are at any given point of time are using somebody's property all the time, either with permission or without permission, right? And you cannot escape from this IP. Coming to this slide, now this slide tells you all the major forms of IP present in the world today. Some countries might use some different words for different things, but more or less these are the most important IPs available or used by people, right? Starting from patents. Okay, patent means innovation or invention. You have trademarks, right? All the logos, symbols, color combination, words used for your brand. To develop your brand, you must have a trademark, unique trademark, which distinguishes your products or services from somebody else's. Okay, then we will discuss about geographical indications, industrial designs, plant varieties, as I said, traditional knowledge, very important. We Indians, we are privileged to have lot of traditional knowledge which is given to us by our ancestors. And a simple thing which is a very common knowledge, right? There is some wound on our body, we immediately use turmeric. Why? Because nobody told us, the medicinal values of turmeric. Our forefathers just used it and they said that it is antiseptic, nothing will happen to you. Much before Dettol and Savlon came, we had turmeric. We did not have toothpaste which are there. We used neem and other things. So in our country, the Ayurveda which we have, it is so developed, it is so advanced, right? There are so many plants and other things which have medicinal properties. And that is our traditional knowledge, that is our intellectual property. And therefore, when the US many years ago tried to have a patent on things like neem and tulsi and turmeric, we oppose them rightly, successfully, because that is our IP. It belongs to us. Then, as I said, confidential information and then copyright. So we have these main forms. As I said, I will talk about copyright in my afternoon session. Today, I will deal mainly with patents, trademarks, and these two, that is geographical indications and industrial designs. In a more detailed manner. The other things I will talk in brief. So coming to patents. Now, patents are the ones, or arguably one of the most important among all the IPs. The most important IP could be patent, because patent is directly associated with an invention And since, say, the last 200 years, whatever industrial revolution took place back then and the present development which we see, it is all about inventions. And why people invent? Because they know that if I invent, I would be given protection under the Patents Act, patent law. Most all the countries have patent laws. So if I have the guarantee that I invent something, I will be given due protection. Nobody can steal my idea, nobody can steal my invention, and that is why they are encouraged. We are all are encouraged to have patents, right? And in the current COVID pandemic, we have this vaccine today not be available to everybody of us right now because of the shortage. That is a different thing. The vaccine has been invented in a matter of what, 6 to 8 months or 1 year. Why? Because these big pharmaceutical companies, whether it is AstraZeneca, Pfizer, Moderna, all these companies, they put billions of dollars into research and development. And why do they put those billions of dollars? Because they know that once we get a patent, we can easily recover that cost along with profits. That is very, very important. Because there is one argument that why should pharmaceutical companies be made to gain from this pandemic? It is not about them gaining. It is about them giving you this drug, giving you this medicine, without which we wouldn't you be able to survive. So this is a quid pro quo, that is give and take. You give one thing and you take one thing. It cannot be a one-way traffic, right? So the section, the act is of 1970. This is an Indian act, and it simply says patent is patent for any invention. Okay, so we move on to what is this invention then? How does law tell us the invention? Because although invention, everybody knows this word, but there are certain essentials, certain ingredients which an invention has to fulfill. Unless that happens, you are not eligible to get a patent, right? So invention is either a new product or a new process which involves an inventive step, right? And thirdly, capable of industrial application. Out of the 4 main ingredients of patent, these are the 3. Without, if any one of these is absent, you don't get a patent, right? So new product or new process, which we call novelty. And what do you mean by new? In simple words, which does not exist at this point of time. Before you made it, before you created it, it did not exist. So a new, it could be product or a process, doesn't matter. You have product patents, you have process patents, right? Involving an inventive step. This inventive step is nothing but a technological advancement, a leap. The leap could be a small or a big leap, doesn't matter. But as a scientist, okay, I identify a certain problem, a certain issue, a certain concern existing in the world today. I'm talking about the world, not just my country or our country. As a scientist, I know that I identify a certain problem, a certain issue, and I try to solve it. If I'm able to do that when nobody else was able to do, then I say that this product or this process is having some inventive step, technological advancement, right? And thirdly, capable of industrial application. It simply means that whatever you invent, product or a process, it should be capable of being used, being manufactured in an industry, being used in an industry. So capable of being made and used in an industry. That means there should be a way to produce it, a mass produce it, maybe you can call it. Right. So all these 3 essentials, once you fulfill, you get you say that you have an invention, and then you go and apply under the Patents Act of 1970. So if I list down these 4 essentials, the first, novelty, as I said, new product or a new process. second is inventive step, third is industrial application, and the fourth, very important, is patentable subject matter. The subject matter which you are claiming as a patent or the invention must be one as mentioned under the Patents Act. If it doesn't fall into that particular section, in fact, I'll show you the section in the next slide, which talks about this things which are not inventions. So there is a list, there's a big list in the Patent Act where some of the things have been excluded from to get this patent. So we say that if your item falls in that list, then it is not a patentable subject matter. So even if it fulfills the first three essentials, it will not be given any value because it will not be given a patent. Right? So let us see what that subject matter is. The title is What Are Not Inventions? Certain things under section 3 are not inventions at all. You don't get a patent criteria. They are very simple things. Some are pretty much obvious. Some are, actual genuine, things, not so obvious or silly. And let us look, at those things in brief. Contrary to natural laws, public order, or morality. Imagine a person inventing a thing for pickpocketing, for stealing. Right? So there are thieves, they pick your pockets. So anything which makes pickpocketing easier, simpler, undetectable, so to say. Then it might be a new product, there might be some inventive step, and it might be capable of being produced in industry. But it is against public order, it is against morality, so not a patentable subject matter. Similarly, anything which is against natural laws, so whether it is about gravity, about say physics, which defies physics or any other science, or the nature, which is against nature, against natural laws, not patentable subject matters. Discoveries, right? There is a very important difference between discovery and invention, which we all know, right? Discovery is something which the thing already exists in the nature, you just find it out. So you are not inventing anything, you are merely finding it out, you are discovering. So discoveries never are a patentable matter. They never get patents because patents are always to inventions and not discoveries. Right? So it could be a discovery of any scientific principle, any living thing, non-living thing, or any properties, new properties which you find in a particular substance. Because all these are discoveries, they cannot be patented. And when I say scientific principles, it also includes scientific formula, whether it is the laws of the motion by Newton, whether it is formulas in mathematics, right? Algebra, trigonometry, Pythagoras theorem, and all other, which you mathematics professors are, which know more than I. So, or Einstein's E is equal to mc square, general theory and special theory of relativity. All these are not invented by those people, they discovered those. They already existed. Or the law of gravitation by again Newton. They did not invent it, they just discovered it. So discoveries cannot be patented. And then admixture, rearrangement, or duplication. So two things existing, you add them and make a new thing. So in fact, it is not a new thing, it is just a mixture of two things. Or duplication, copying features of one product, putting it in another product, you are duplicating it. Or only rearranging the things. So not an invention. Methods of agriculture, horticulture, etc. The way farming is done, we are not talking about the products used in the farming or the machines used in the farming, but the method of farming, method of doing it. And the process, the method, whether it is agriculture, horticulture, or any other, pisciculture, viticulture, etc. All other things, those methods cannot be patented. This is very important. process of medical treatment. Now, there is a difference again here. We are not talking about drugs or medicines. We are talking about the process of treating a person. Now, in the medical world, nowadays, there is so much technological development, right? There is a microscopic surgery available these days. Any part of the body, they don't cut our body open altogether. They just incise, there's a precision. And through a microscope, they only insert one thing and they do it. Or whether it is laser technology, right? By the use of laser, there are so many surgeries done. So those machines, they are still patentable. But we are here talking about the process to treat a person. So say maybe a treatment chart or a treatment schedule. So for example, for COVID, what kind of treatment should be given? You have some medicines, whether it is remdesivir or dexamethasone, or nowadays you have so many other things. So you prescribe so and so antibiotics, you prescribe so and so antacids, right? Whether it is paracetamol or any other thing, immunity boosters, and you prepare a template, a model to be followed by everybody. So now this is a process of treating COVID patients. So whoever comes up with this cannot claim that it is their thing, because it is mere a process. But the medicines, the antibiotics which are there, they are definitely patented. Plants and animals. Now again, plants and animals are a thing which cannot be patented. There is one exception though, that is of microorganisms. Microorganisms have been excluded from this section 3, so to say. You can still have a patent over any microorganism where you have, let us say, partially invented, because the basic source of microorganism is already there in the nature. You take it, you experiment upon it, you add certain things, you change the DNA of that organism, and thereby that microorganism gets new features. I remember one case happened in the 1970s, if I'm not wrong, in the US. It was about a microorganism, a bacterium, okay, which was modified genetically by an Indian origin scientist in the US. The feature of that bacterium was that it was very much effective in breaking down or splitting the oil molecules. Now, we would say, what is so important about splitting oil molecules? This is important in the oil spills which happen in the ocean, right? You might be aware of this problem. Oil container, stuck in the ocean, some accident, and the entire oil spills into the ocean. Because of that, lakhs and lakhs of flora and fauna, they are dead because of the oil spill. So this scientist invented or modified the bacterium and successfully got a patent for that microorganism. So that whenever there is such oil spill, you are able to deploy these microorganisms who are able to split the oil molecules so that it doesn't cause much harm to the environment. Okay. Then, as I said, any mathematical formulae, algorithm, business methods, or computer program per se, they are not inventions at all. Computer programs are actually covered under copyright. It is nothing but a software. They are covered under copyright. Similarly, copyrightable works. Any work which is covered by copyright has been excluded under patents. Right? So now, once you decide that you have an invention, it fulfills all these criteria, including these sections, then you apply for a patent, and if you get a patent, the duration of such patent is 20 years. After 20 years, it falls into public domain. That means anybody is free to use that patent for any reason, any purpose whatsoever, without authority, without permission of the owner, the patentee, the one who owns the patent. Right? So 20 years is the maximum period. So you have any patents today, you think of any patent, their life is 20 years. After 20 years, it is, it falls into public domain. You cannot do anything about it. There is no renewal of a patent. So the people who invest, lakhs, crores of rupees, billions of dollars, they have this shelf life, they have this limitation of 20 years to recover that entire money. And that is why we see that in medicines, I can come back to medicines, you have a branded drug which costs say maybe 40 rupees per tablet, and the generic version of the drug is say 5 rupees, for example, or 2 rupees. Why? It is not the cost of manufacturing the drug, it is the cost of invention, the crores of rupees which have gone into invention, right? Because they have to recover it, and that is important. If you don't recover that, why would anybody in future invest so much of money without the way of recovering it? So you have this 20 years, and that is why these branded things are always costly, because of the cost of IP involved in it. Renewal fees are to be paid every year or every 2 years. Okay, so but it is up to 20 years. Every 2 years you pay renewal fees. There are, again, having a patent is a costly affair. If some of you or some of the institutions where you work, you might have a patent, right? You might be working, in that department. Some of you, if yes, you know about these things. How costly a patent can be just to maintain. I'm not even talking about having an invention. That is costly. There's no doubt about it. But even maintaining a patent is costly, right? So these are the things, basic things of a patent. The things which subject matter of patent, what can be patented, what cannot be patented, the duration, etc. There is another aspect which I would like to touch upon here before I move to the next intellectual property, and that is compulsory licensing. Okay, under Patent Act, there is one provision where the government can compulsorily issue a license to any manufacturer to produce a patented product. It has been used only once so far, almost more than 10 years ago, when there was a case between there was an Indian company known as Natco Pharma versus Bayer Incorporation. Bayer Incorporation is a multinational pharmaceutical company, and they had invented a drug for cancer, to treat cancer patients, and they got a patent in India, but they were not producing it to meet the demands of the country, our country, and they were not even importing it from outside. And so for 3 years we patiently waited for them to do it, to use it for the benefit of our people, but they did not do so. And plus the price was too high, completely unaffordable to any cancer patient in India. And so government used this compulsory licensing provision and granted a license to Natco, a company Natco, where they were allowed to manufacture a generic version of the drug. Now, why am I telling you this is, there is a possibility that we could do the same thing for the COVID vaccines. Because if this is not a national emergency, then what is? Okay, we had only one emergency so far in 1970s in the Indira Gandhi government, but this is a different kind of emergency, a medical emergency. So my personal opinion, we could have by now invoked the Patent Act and the compulsory licensing to manufacture these drugs at a generic level on a mass production on a large scale. That is the only way out to come out of this pandemic, right? So there are so many but hurdles, obstacles. It is not as easy as said, right? So after having studied these basics of patent, now let us come to the next IP. I hope so far whatever I said you are able to hear properly with clarity, and were able to understand. If you have any doubts, any queries, you can interrupt me right now, or you can, we might have a Q&A session subsequently also. Coming to the next kind of IP, that is trademarks. So trademark, as you can see on this screen, it includes so many things. Okay, words, letters, shapes, signatures, logos, color combination, label, drawing, etc. Right. So when I talk about, so look, everybody knows what logos are. Every institution, every organization has a particular logo. That logo is the trademark of that institution. Now, whether you register it or not doesn't matter. It is not compulsory to register a trademark. Okay, it is not compulsory. So to get the protection, it is not compulsory that you must register it. Unlike patent, where getting a patent is compulsory. You cannot just have an invention and expect protection from the law. No. So trademarks, I can here today itself by sitting here, I can create a logo for my association, organization, or my business. Without even registering, I can use the symbol TM, short for trademark, and a circle. That means that I am claiming this logo as my trademark, or I am claiming this particular word as my trademark. So use these words TM and a circle in front of every logo which you may have as an institution. It actually gives a warning to the entire world that you are claiming it as a trademark. If anybody else copies it or uses a similar logo, you can file a case against them because of the TM symbol. And if you want to go ahead and register your trademark and do it, that is also advisable. Then you use the symbol R and a circle. So R denotes registered trademark, whereas simple TM says unregistered trademark. Right? And your college, PPG college, has a logo. I saw in the brochure, this FDP brochure, the pamphlet. So go ahead, use this TM symbol if it is not already registered. And you have color combination. So imagine any brand. So when you think of McDonald's, you think of the big M and yellow color. No other color. Yellow color is McDonald's, or Domino's has blue. Right? So many others. Google has this combination of 4 colors, red, green, yellow, blue. So that is color combination. That is also protected under law. You cannot use the similar pattern color combination. Right? Then you have drawings, you have shapes. I will talk more about shapes in my next slides. Or signature. So even a signature of a person can become a trademark. Right? So basically, what are these trademarks? Trademarks are nothing but any, as I said, any word, logo, symbol, device, label, drawing, picture, color combination, shape. Nowadays you have smell also, right? Motion pictures, GIF. All these things which you use for your business or service to identify yourself, more importantly, to distinguish yourself from that of somebody else. So your service, your product must be distinguished from other product, and you use this trademark to distinguish yourself. And over time, this trademark, this trademark is so distinguished that people associate quality with that trademark or with that logo. Right? So you think of any well-reputed brand in any field, right? In every product which we use, whether it is as simple as toothbrush or toothpaste, or it could be medicines, people have constantly made these trademarks well known. And that is a distinguishing feature, and that is the main feature of a trademark, distinguishing your product from somebody else's. So a person, by just looking at the packaging or the logo or the color combination, they come to know that this belongs to this group or this company, and because that company might have a good name, goodwill,
you associate, you buy it blindly. That is the importance of trademark. So then you, again, in trademarks, you have different varieties, different kinds. Okay, I'll just touch upon a few of them today, just for your knowledge. Now, whatever you see here, right? Visa, Subway, Canon, FedEx, Disney, Google, Jeep, Philips, Coca-Cola. Now here, figurative mark includes not only these words, but the font which is used, the style, including the color and the entire thing as a whole. That is the figurative. So not only in Visa, not only VISA is protected, but the blue color, the small orange which comes there, it's a slight italic, all that design, the complete thing is protected under trademarks. And you take any such example, right? The fonts are different, the colors are different. Some are capital letters, some are small, some are unique, like the Subway where you have arrow marks. For Amazon, if you see Amazon, there is a smiley like arrow mark which goes from A to Z. So they want to say that we have everything from A to Z. Everything is under the same roof, and that is the arrow mark. So all of this, they are protected under law. Then you have some other marks. For example, our profession, advocacy, we use this advocates. We, in the sense, I am not an advocate because I am not eligible to practice, right? And who are those people who are eligible to practice, who want to practice, who have that enrollment certificate? They can use this symbol. Similarly, chartered accountants, cost and management accountants, these are collective marks. So there is a difference between the collective and the other marks. The main difference is, in other cases, only one person, that is a Canon, only Canon company can use the word Canon, not anybody else. But when you come to collective marks, anybody who is a chartered accountant, anybody who is a cost and management accountant, anybody who is an advocate can use these logos. So we say collective marks. Similarly, doctors have a symbol of their own, right? I think the engineers might have something of their own. So used by a collection of people. And certification. Now this is very important. Certification marks. See these logos. You might be able to recognize these. Right? ISO. Now many companies are ISO certified companies. In ISO there are so many different classifications or groups depending on the nature of business or nature of service. 9001 is just one category of so many other categories. So ISO is short for, as you can see here, International Organization for Standardization, ISO. So if your company is ISO certified, you can use this logo on all your products or your services or wherever you communicate with people. You can use this logo. You can tell it proudly to the people that our company is ISO certified company. Right? So it is like the NAC gradation. If you have A or A+, right, you can proudly say that we are accredited by or with this so and so grade. Right? So similarly, CE, I hope you know this. Any technological product, if you have a mobile phone with you, you have a laptop with you, look at the spare parts of the mobile phone, the battery or adapter, the charger, they will have this logo, CE. This is a European certification for these electronic gadgets. Similarly, ISI is Indian Standards Institute, where it talks, so it is applicable to only India. Similarly, you have hallmark, right, for jewelry. You have ag mark, that is for agricultural mark for agricultural products. So all these are certification marks. They also come under trademark. So you are eligible to use these if your product or service satisfies the standards put by these or laid down by these institutions, and you have a certificate from them. Then you can use these marks. And then coming to unconventional marks. Unconventional are very modern kind of marks. They are not your traditional typical marks. Okay, so for example, let me give a few minutes for each of these images. Now here in the first image you have Heinz beans. Heinz is a company. Heinz ketchup is famous in India rather than beans. So Heinz ketchup, the same company, produces these Heinz beans. So in the US, they have got a trademark on this product based on this blue color which they have on their tin packaging. So they have successfully got a trademark. What that means is Heinz beans. So Heinz company can use this blue color on beans, and it can prevent everybody else, all other beans manufacturers, from using a similar color and similar packaging. Why? Because over a period of time, the company has been successfully able to connect with the market based on this blue color and the packaging. And it's a very rare thing. See, not everybody will get a trademark for the color, because color is common, everybody can use any color. But in some cases, your products can be given these unconventional trademarks. Similarly, come to Toblerone. Toblerone is a chocolate, some of you might know that the shape of Toblerone chocolate is like pyramid, small pyramid shaped chocolate. So they are able to get a trademark for the shape of the product, right? For the chocolate. Similarly, Coca-Cola. Now I'm not talking about the recipe, the drink here. I'm talking about the shape of the bottle. Right? Of course, I will talk about this even when I talk about designs, at the end of this slide, this presentation. But the shape, there is a story, very interesting story, which goes, that many years ago, the company gave a task to their designers to come up with such a unique shape of a bottle where a person would be able to recognize the bottle even when the room is completely dark. So without seeing, just by touching the bottle, one should be able to recognize that this is a Coca-Cola bottle. That was the task given to designers by the company. And then they came up with this image, this shape of the bottle, which you can see here. This is a glass bottle. Plastic bottles have a different shape. But the glass bottles, nobody else, no other drink in the world uses the similar shape, because they have got a trademark over the shape. Right? So, that is another example of how you can establish your image, in the market. Then, just like patents, when we saw that certain things are not patentable, similarly, certain trademarks cannot be registered. Even though they might fulfill all the essentials, they cannot be registered. For example, any mark which is not distinctive, which is not unique, which doesn't distinguish your product with somebody else. Secondly, which are identical or deceptively similar to some other mark. So you copy someone else's logo or you make it similar. Say for example, Colgate. The actual Colgate is COL. Now what you do is you copy everything, but instead of C, you make it K. Pronunciation is same. The color is same. The design is same. But the word is different. But you cannot escape because that is deceptively similar. Right? There are so many such examples. I'm just giving you some. So third is hurting religious sentiments of people. Religious sentiments is one thing where Indians are easily offended, and for the right reasons or the wrong reasons. I'm not talking who is right, who is wrong. But in India, always somebody or the other is always offended by something. Now, because now you're from Coimbatore, Tamil Nadu, one thing which I just recalled, I don't know much about the politics there, but some person gave some interview some days ago about a web series on Amazon Prime, that is Family Man 2. I have not seen it. Season 2, that is in question now, controversy. Why? Because according to some people in Tamil Nadu, it shows the Tamilians in bad light. right? And they are opposing. They are demanding a ban on this family season web series. I don't know, who is right, who is wrong. I'm not going into what is right, what is wrong. What I'm telling you is anything which has a potential to offend any religious community in India or the world, such trademarks cannot be registered. Then they are scandalous or obscene in nature. Okay, and lastly, state emblems. So whether it is state flags or emblems of army, navy, air force, police, right, or different ministries, different departments, such things cannot be trademarked. The term is 10 years. Now this can be further renewed for another period of 10 years and so on. There is no end to protection of trademark, unlike the patents, because after 20 years patent falls into public domain, whereas trademark does not. Once 10 years are over, you can renew it further for a period of 10 years. After that, so on and so forth. There is no issue there. All right. So moving on quickly to the next IP, that is geographical indications. I don't know how many of you are aware of this term, because this is not that common, or people are not that aware of this GI, this IP, rather than the other, compared to other IPs. Geographical indication is that product which has unique features because of the geographical factors. So whether it is temperature, soil,
climate, or the people surrounding there, the humidity, the cold temperature, hot temperatures, the nature of soil, mud, water, all these things. These are all natural geographical factors. So imagine a product which is famous because of the geography, because of the location. And one of them is, right in your city of Coimbatore, and which, might be in all your houses. If you are living there, you might have that product in your home. Okay, I'm not telling it right now, keeping it suspense, but that is a geographical indication belonging to Coimbatore. Coimbatore has only one GI, right? Tamil Nadu has so many. Tamil Nadu has, I think, 38 GIs. I'll talk more about it, but let me tell you, some of the examples you will come to know immediately. For example, Darjeeling tea. Darjeeling tea is manufactured only in Darjeeling, okay, not anywhere else. And that tea, whether it is even coffee, in those places, or Assam tea, that tea gets that particular taste and aroma smell because of the unique geographical locations of that area. So the people who produce that tea there, they get this protection under Geographical Indications Act of 99, whereas they can prevent everybody else to sell the tea with this name, Darjeeling tea. In other words, you can bring a sapling of tea here in your city, you can grow it there, right? And you can also manufacture tea from it, but the taste will not be same, right? And even if it is same, you cannot sell it as Darjeeling tea. You could sell it as Coimbatore tea, not a problem, but you cannot sell it as Darjeeling tea. Why? Because it is a protected geographical indication under so it is another form of intellectual property, right? Then you have these betel leaves from Mysuru. So the betel leaves which we eat after our food, pan, which we call. So these betel leaves are from Mysuru, Karnataka. They are protected. Then you have silk sarees. Now you have your own silk saree in Kanchipuram, which is a GI, which I'll show in the next slide, will maybe come. Here, this is a Mysuru silk saree, right? Then you have sandalwood from Mysuru. Here you have textile, that is chadar, what we call Solapur chadar. Solapur is a place in Maharashtra which borders Karnataka. And Solapur town is famous since hundreds and 200s of years for textile. right? So many napkins and towels, they come from Solapur. And this is Mallige, that is Malli we call, or jasmine. This is again from Mysuru. This is wool. So if anybody can guess, this is Kashmir Pashmina wool. Now, if anybody have visited Kashmir, you know about this Pashmina wool. You might have had your friends, family visiting and bringing such as a souvenir, as a gift. One unique thing about Pashmina wool is the shawls which are manufactured from this Pashmina wool. They are so thin and soft that you take a finger ring, okay, ring which you wear, finger ring, the entire shawl will pass through that ring completely. That is how soft such wool is. That is a unique feature of wool. Another feature, they say that these shawls are multi-purpose. That is all season. In winters, if you want to become warm, use these shawls. It will keep you warm. In summers, it will keep you cold. I'm not sure, to what extent that is correct, but that is how they claim. Then this is wines from Maharashtra. So the name is Sula. The person who started this company was working in the US. He was, I think, in Stanford. Stanford graduate, maybe, working in the US, but he had some family land in Nashik district of Maharashtra, which is suitable or ideal for growing grapes. The soil, the temperature, weather is ideal for growing grapes, and you know that from grapes you manufacture wine, you produce wine. So he established this Sula wine. Sula is after her mother, known as Sulabha. So Sula wine is very famous destination in Maharashtra, and they have a big place. And out of, I think, more than 70% of wine in India comes from this place, and it's a very famous brand. This is from Tirupati, placed closer to you. Tirupati laddus. They have successfully got a GI protection, GI tag on these laddus. Okay, because of the unique recipe and the ingredients which they use, they are able to prove that this is unique to Tirupati only and not anybody else. This is another sari known as Paithani sari of Maharashtra. This is a GI, and all Paithani saris will have peacocks in them. That is the unique feature. Peacocks, all different types of peacocks on the saris. Strawberries from Mahabaleshwar. Again, Mahabaleshwar, it was not originally from Mahabaleshwar. Some people brought it from Australia. They planted it in Mahabaleshwar because of the hill. It is a hill station in Maharashtra, for those who may not know. So that hill station, that area, weather is ideal to grow strawberries. Okay. Yes, and coming to this product, as I said at the beginning, this might be at your homes. This is a wet grinder. This is a Coimbatore product, originated in Coimbatore. You might be using. I've never seen it personally in life, but you have used it. This is a Coimbatore wet grinder which got geographical indication protection in the year 2005 or 6, I guess. I'm not sure about the year, but somewhere around that time, they got a GI tag for this. And around, I think, every year, almost 1 lakh wet grinders are manufactured in India. Out of that, 75% of them come from Coimbatore. Right? And you know more about this than me. And just to end this, let us make you aware, if you are not aware, of different GIs which are there in Tamil Nadu. Right? Some of them you might know. I do not know any of them. Salem fabric, Kanchipuram silk, Bhavani, Jamakkalam, Madurai, Sungudi, Tanjavur paintings, temple jewelry of Nagarcoil, Tanjavur art plate, East India leather, Kovai Kora cotton sarees, Swami Malai bronze icons, Virupakshi Hill banana, and Madurai Maldi. These are only some of the early geographical indications which were given to Tamil Nadu. But there are, as I said, more than 38, almost 38 GIs belonging to different parts of Tamil Nadu. Right? So that is how GIs are so important. The main object is to promote the product, because of which it has got this unique facility, and prevent others from copying it. Thereby, you make that product famous and also give livelihood, employment to all those people who are involved in that particular area. So it has a dual purpose. Protection. The purpose of protecting is multi-purpose. All right. So all other things are same like trademark. Protection is given for 10 years, can be further renewed for another period of 10 years, and so on. Okay. Then come to the last IP, which I'm going to talk in detail, and then I'll conclude this session. This will not take much time. Designs is another IP, which is again not that common. Not many people are aware of this act. Not many people use this act. But Designs Act is, it recognizes the unique designs of different products. Now, it is always judged through the vision. Any product which appeals to our eye, appealing to the eye, rather than the technical features or usefulness. Anything which is appealing to the eye can be protected under Designs Act. So that you come up with a unique design, and because it is unique, people will remember it, people will use it, because it is completely unique. I will show you some images of unique products which can be protected or which are protected under designs law. So it is basically industrial designs. So any design which might be applied on a particular product or particular article. It must be visually appealing. As I said, it must appeal to the eye rather than, so it may or may not have any useful features or technical features, right? But it must be visually appealing. Okay, so for example, now this was one of the iconic cars in the previous century. In fact, this car, before this car came, the designs of the automobiles was completely boring kind of thing. It was nothing. There was nothing attractive about it. But this car, which some of you might have recognized, is a Mini Cooper of 1950. One of the most famous cars of the previous century is Mini Cooper. And this was the first. Now, today you might say that this is a very usual design, because nowadays we have so many new designs. But at that time, this was one of the most unique designs of applied to a car. Okay, it's a hatchback car. There were not hatchback cars back then. You had big bonnet and big the rear, the dicky, what we call. This is a hatchback. So unique design, Mini Cooper. Then, as I said, I've already talked about this Coca-Cola, the shape of the bottle. Now, they used this shape first time in the year 1915, and I've already told you the story behind it, of how they were asked to recognize it in the dark, and they came up with this unique shape. Again, now today this might seem a very common feature or sight, but back then, Piaggio company came up with this Vespa. Even now, very recently, they've come back with a renewed version of Vespa scooters. But this shape, which it was very unique back then, those days, right? So because no other scooter was like this, no other two-wheeler was like this. Today we have so many such things. This is unique. I have not seen this personally anywhere physically, but it is a lemon squeezer, as you can see. You can see in the image. It looks very unique. It looks like something else, but it is very useful. You squeeze the lemon at the top, all the juice gathers at the bottom in the glass. So you might say that you can just do it by some other method also. Yes, but the product itself is unique. It suddenly catches your eye, and that is the feature of design. Design which catches your eye immediately can be protected under Designs Act.
Another such example of a chair. Now this is a chair to rest. But at the same time, if you can observe here, there is a lamp, overhead lamp. So, and if you give momentum to this here, it will keep on rocking back and forth, rocking chair, swinging chair, along with the lamp. So you can read if you want to. But more than anything else, more than the swing and the lamp, the thing is the unique shape which it has. Suddenly catches your eye. Another such example is this bicycle which these people are carrying on their back. So this is a folding or foldable bicycle. So if you want to go on a hike, hiking, you don't have to carry it in your hand. You can just wear it as a backpack, go to the top and then come down with the bicycle, unfold it. Once you unfold, it becomes like this. There is no seat, so you cannot sit. And because there is no seat, you can fold it. That is one unique thing. And then you can rest your legs here in this way and come down. This is not for going up, it is for coming down, this bicycle. Right? But it is foldable, so it is unique. Another such example is this sink. Just imagine you yourself washing your hands and mouth in this sink. Right? So it's a live aquarium. You have fishes there, but it is a sink. So both the purposes. So unique design. And lastly, here you can see the evolution of the Apple computers. This is the left hand side is the first Apple computer. First in the sense in the modern days. Before that also there were certain designs, but the Macintosh, what they call, so that evolved like this. So they became thinner and more costlier. So more the thinner it is, costlier it became. Right. So that was about, in brief, about design set. Right. So to conclude this session, okay, now I've spoken about patents in brief, trademarks, GIs and designs. I will talk about copyright in my afternoon session. Right. Now, a few things I've already talked about: confidential information, that is trade secret. Okay. Traditional knowledge, again, whether it is neem, tulsi, turmeric, anything in Ayurveda is our traditional knowledge. Cannot be, it is our IP, although there is no special law to protect it, but it is considered as traditional knowledge under this umbrella of intellectual property. Right. And similarly, you have different plant varieties. As I said, there is a separate law for plant varieties, Protection of Plant Varieties and Farmers' Rights Act. So different varieties manufactured or produced, invented, which have some hybrid, what we say, mix something and create something. Those kind of varieties are protected under that particular law. Right. So this was just a small effort or attempt from my side to make you aware of what different forms of IP are, because 1 hour is not sufficient to deal with such a huge topic. So I think I have tried my best to make you aware of the different forms of IP which are present. And so I conclude here. Thank you so much for giving me time to speak with you all, to present my thing. If you have any queries, questions, you are free to ask me.
Sir, there are questions posted in chat box, sir.
Yes. Couldn't hear you properly.
Kumaresan Vadivelu, sir. When a novel drug that is patented is produced by a company, can it be sold as generic drug? This is question from Kumaresan Vadivelu.
Okay. So, as I said, a pharmaceutical company will put billions of dollars in inventing a drug. Right? So it will not allow anybody to make a generic version of it. Thereby what happens is people will obviously buy the generic version and nobody will buy the patented drug. So the general answer is the patent law doesn't allow all patents to be made into generic versions. No.
only in exceptional situations, only in unusual situations, the patents can be made generic, but not all. Or in some cases, there could be an agreement between the company and a particular country, whereas the patented company itself allows the people to make generic version to a limited capacity. But it is either an agreement or only in case of emergencies, compulsory licenses can be issued. So to answer you, no, patented, they are eligible for a patent, they have got a patent, and they should be able to get all the returns on their investment.
Okay, sir. So next question by Ramachandran Alagaya, sir. Whether the film songs belongs to producer, director, actor, financier, musician, or singer, or lyricist?
Sorry, I didn't get the first part. What belongs to whom?
Sir, the film songs belongs to whom?
Songs.
That is the producer.
Okay.
Yes, sir.
Yes, songs. So yeah. So now I will talk more in detail when I talk about copyright, because this comes under copyright. But let me answer you in brief. A song has different copyrights. The person who writes the song, that is a different copyright. The person who gives music, that is a different copyright. Usually what happens, the producer, whether it is a cinema where you have different songs, so there is a cinema producer, or if it is a music album, there is a producer. So producer owns all the copyright in his particular work. So the producer and the songwriter have an agreement. So all the rights here, generally, they go to the producer. So producer has the copyright over all those things.
Sir, next question by the same person, Ramachandran Alagaya, sir. So do you think there is a way to recognize the discovery?
Recognize the discovery? No. As I said, simple answer is, because it is a discovery, you have not done anything. You have not invented it. Your efforts are limited only to find it out. So it doesn't belong to you. It belongs to somebody, or belongs to the nature, and you have just found it out. So discoveries are not inventions. There is a clear line between a discovery and an invention, and discoveries are not patentable, only inventions are.
Okay, sir. So next question, sir. Who defined the patent and in which year?
Patents Act of 1970. So in that act, all these definitions are given.
Okay, so that's all the questions from chat box, sir.
Okay.
Participants, do you want to ask any questions to sir? You can ask now. The forum is open. Sir, I think no more questions, sir.
Okay.
Hari Krishnan, sir, shall we wind up the session? Thank you, sir, and thank you, participants. Participants, we are expecting your valuable presence in the afternoon session too. So, participants, kindly join the afternoon session 10 minutes prior to the session by 1:50 p.m. Thank you all.
Thank you.
Madam, please share a feedback link.
Yes, ma'am.
Should I leave the meeting, ma'am?
Yes, sir.
Okay, thank you.
Thank you, sir.